Welcome to the fifth video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I'm intentionally giving away all the substantive content of the book. If you watch all 9 videos and internalize the concepts explained in those videos, you will have expert knowledge of interrogation law without spending anything but your time. I think you will find, however, that the book, and particularly the many case examples found in the book, are a valuable supplement to your viewing of the videos. It is bargain priced and available for purchase on Amazon. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. So, on to today's lesson. This is video 5, which covers the Sixth Amendment right to counsel. 2 distinct rights of counsel are litigated in confessions cases. A Miranda right to counsel that protects the Fifth Amendment right against self-incrimination. It is triggered by custodial interrogation. There is an entirely separate Sixth Amendment right to assistance of counsel for the accused in all criminal prosecutions. It comes into play when there is interrogation after the initiation of adversary judicial proceedings. Cases sometimes describe the Sixth Amendment right to counsel as coming into play when it has attached and the matter is at a critical stage. In the interrogation context, this means that these 2 things exist. Adversary judicial proceedings have been initiated, whether by way of formal charges, preliminary hearing, indictment, information, or arraignment. That's called attachment. 2, the suspect is being questioned either overtly by an officer or covertly by a law enforcement agent, an undercover police officer or cooperating informant. This is a critical stage. Sometimes suspects have attorneys on the particular charge or on some other case. This does not cause the Sixth Amendment right to counsel to attach. This is important because if the Sixth Amendment right to counsel is not attached, represented suspects may be interrogated without violating the Sixth Amendment. In short, Miranda requires custody and the Sixth Amendment requires attachment. If the suspect is in custody, evaluate the case under the Fifth Amendment, the Miranda rule. If the suspect has been formally charged, evaluate the case under the Sixth Amendment. If the suspect is in custody and has been formally charged, consider both. If the suspect is not in custody and has not been formally charged, neither apply. The Sixth Amendment attaches with the initiation of adversary judicial proceeding. The Sixth Amendment does not attach if the suspect has merely been arrested, has an attorney, or is the focus of an investigation. Typically, attachment occurs with an indictment, but misdemeanor or preliminary complaints may suffice if they are formal charging instruments, and any complaint will suffice if the suspect has been arraigned on it. A complaint prepared pursuant to Federal Criminal Procedure Rule 3 to obtain an arrest warrant is not a formal charging instrument, so the right to counsel does not attach until arraignment or the filing of a more formal charge. As stated earlier, the Sixth Amendment right to counsel comes into play when it is attached or the matter is at a critical stage. There are a considerable number of cases discussing whether certain events or court proceedings are a critical stage. But for the purpose of this video, it is sufficient to say that any questioning of a defendant by a law enforcement officer or the officer's agent, for example, a wired cooperator, custodial or non-custodial, after the right to counsel is attached, is a critical stage. As we noted in the prior video, the Fifth Amendment Miranda definition of interrogation is words or actions on the part of the police other than those normally attendant to arrest and custody that the police should know are reasonably likely to elicit an incriminating response from the suspect. Courts apply a subtly different definition in Sixth Amendment cases. Sixth Amendment interrogation occurs where statements are deliberately elicited by a government agent. On a theoretical level, the Fifth Amendment standard is objective, what an officer ought to know, whereas the Sixth Amendment standard is subjective, the officer's actual intent. It is possible to find cases that attempt to make something out of that distinction, but the number of these cases is vanishingly small. The Sixth Amendment right to counsel is offense-specific. This is true even if the crimes are closely related or factually intertwined. As we saw in the last video, the Fifth Amendment is not offense-specific. What does this mean? Let's say, for example, that somebody named Smith is arrested on a burglary indictment. The victim of the burglary has been missing since the burglary, and the police strongly suspect that Smith killed the victim during the burglary and then disposed of the body. In other words, the burglary and the murder are closely related and factually intertwined. The Fifth Amendment is offense-specific. It bars custodial police questioning about either crime without a Miranda waiver. The Sixth Amendment right to counsel is not offense-specific. It requires Miranda warnings and a waiver regarding the burglary because of the burglary indictment, but it does not bar unwarned questioning about the murder. If the suspect is later released from custody, the Fifth Amendment Miranda requirement no longer applies to either charge. The Sixth Amendment right to counsel continues to apply to the burglary, but not the murder. That is, Smith can be questioned without Miranda warnings about the murder, but not the burglary. Let's change that factual scenario slightly and leave Smith in jail for a few days. Police instruct a cellmate to ask Smith about the murder. As we saw in the last video, Smith is not in Miranda custody, so the questions are not barred by the Fifth Amendment. The Sixth Amendment bars the use of any resulting statements against Smith in the burglary trial, but they would be properly admitted in the murder trial. Let's add one more fact to this last scenario. Let's say that Smith retained an attorney on the burglary charge right after he got arrested. Once again, there is no Miranda custody and hence no Fifth Amendment issue. As explained earlier in this video, representation by counsel by itself does not create a Sixth Amendment issue. The cellmate elicits incriminating statements from him. Once again, the Sixth Amendment bars the use of those statements against him in the burglary trial because Smith had been indicted for burglary, but not in the murder trial because the Sixth Amendment is not offense-specific. Now, your prosecutor will get nervous about this, and the defense attorney will get apoplectic. If the circumstances are aggravated, the defense may put together a plausible claim that it was a product of a contact with a represented party that should be suppressed. This is unlikely in most cases, especially if the prosecutor was not involved. We'll talk about that in the next video. But nothing in the Fifth or Sixth Amendment would bar the questioning of Smith about the murder or require any warnings or a waiver. Many more scenarios are possible. For example, if the suspect in custody invokes Miranda rights, police are not free to ignore the invocation and switch the interrogation to another crime because the Fifth Amendment rule is not offense-specific. But the same invocation where the suspect is not in custody, but where the warnings and a waiver is sought because of a pending indictment, would not prevent questioning about an uncharged crime. Examples like this no doubt make your head hurt. But if you take the time before an interrogation to carefully examine which constitutional protections apply, considerations such as offense specificity create tactical opportunities. Officers setting up undercover operations and supervising informants must understand these fundamental principles. The Fifth Amendment Miranda rule does not ordinarily come into play when suspects are questioned by an undercover officer or informant, because the suspects don't perceive themselves as experiencing custodial interrogation by law enforcement. It is not a police-dominated atmosphere. This is true even if the suspect is in jail or prison. The Sixth Amendment right to counsel, however, bars the questioning of the suspect regarding a crime if the Sixth Amendment right to counsel is attached to that crime. The suspect has been formally charged with that crime. Consequently, undercover officers and government informants must be specifically instructed to refrain from eliciting statements from suspects regarding charged crimes. They can report back on any incriminating statements that the suspect volunteers, but they can't ask about a charged crime or in any way stimulate conversations about that crime. If volunteered statements are obtained, it will be necessary to provide a detailed account of the conversation that eliminates any possibility that the statement was prompted by a government agent. As explained earlier, the Sixth Amendment right to counsel only applies to crimes that have attached. If, for example, the informant elicits incriminating statements about other crimes that have not been charged, even if these crimes are closely related to the charged crime, the Sixth Amendment is not violated. Put another way, if a jail inmate is being investigated for another crime, even a crime closely related to the one that the inmate is being incarcerated for, there are no constitutional issues under Miranda or the Sixth Amendment. Your jailhouse stool pigeon or your undercover officer can deliberately elicit statements from the inmate, and the inmate's statements will be fully admissible in court. There's a separate Sixth Amendment right to effective assistance of counsel that includes the ability to speak candidly and confidentially with counsel, free from unreasonable government interference. Courts have found that such practices as jailhouse monitoring of phone calls, the opening of law mail, and the use of informants may violate this Sixth Amendment right to effective assistance of counsel. 5 factors are considered. Did the government purposely intrude into the attorney-client relationship? Was evidence offered at the trial obtained directly or indirectly from the intrusion? Did the prosecutor obtain any details of the defendant's trial preparation or defense strategy? Were the overheard or intercepted communications used in any other way to the substantial detriment of the defendant? Finally, was there a legitimate law enforcement justification? Jails and prisons generally have formal policies governing such practices. Stepping outside those policies is a bad idea. Anything like this ought to be by the book and approved by government attorneys. Interference with such communications may also be a violation of the Fourth Amendment, illegal wiretap, illegal seizure of mail, etc. A thorough description of the Fourth Amendment in this context is beyond the scope of this video. Waivers of the Sixth Amendment are judged by the same standards as Fifth Amendment Miranda waivers. The same waiver form is used. It is perfectly lawful to approach suspects who have been indicted and have counsel, and without notice to counsel, obtain a Miranda waiver and statement. The Miranda waiver is essential even if the suspect is not in custody. The Sixth Amendment right to counsel attaches with the filing of formal charges, whether or not the suspect is in custody. This is a routine matter if the suspect has no counsel. For example, an officer serving an arrest warrant on an indicted suspect, that is, after the Sixth Amendment right to counsel is attached, may lawfully obtain a Miranda waiver and question the suspect before or after the arraignment. This becomes a matter of some sensitivity if the suspect has an attorney. Be prepared for some animosity from defense counsel or even the judge. Avoid needlessly antagonizing them by, for example, disparaging the suspect's attorney during the waiver and interrogation. It will make prosecutors nervous too. They are generally barred by ethics rules from directly contacting represented individuals. Exceptions apply to this. We'll cover them in the next video. And they don't want to be accused of using police officers to circumvent their ethics rules. Because of all of this, I want to be perfectly clear and identify the key Supreme Court decisions. First, in Michigan v. Jackson, 1986, the Supreme Court held that requests for counsel at arraignment constituted invocations of the Sixth Amendment right to counsel that would bar subsequent police-initiated interrogation, similar to the Edwards rule applied in Fifth Amendment cases. 2 years later, in Patterson v. Illinois, the Supreme Court held that waivers of the Sixth Amendment are judged by the same standards as a Fifth Amendment Miranda waiver. Finally, in 2009, Jackson was overruled in Monteo v. Louisiana. Prosecutors accustomed to following the older Jackson rule, which is around for 20 or 30 years, may not have fully appreciated that Monteo has the effect of expanding Patterson to cover post-arraignment interrogations of represented defendants. Be ready to refer the prosecutor to Patterson and Monteo when you present a case that raises these issues. The FBI agents are still discouraged from obtaining waivers from represented suspects, even post-Monteo, without notice to counsel. So, you made it to the end. Thanks for that. If you have comments about the presentation or questions about some of the points I have tried to make in the video, I can be reached by email at contact@trialdex.com. This was the 5th video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. The next video covers ethical no-contact rules. I hope to see you there.